All right. Hi, everyone. Welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you so much for joining us this afternoon. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from both members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions, and we provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered, our webinars page. We also record our webinars, so if you missed part of today's webinar, or if you just want to go back and watch it again or find a different one, they are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. And if you would like to download a copy of the PowerPoint right now, I am sharing a file for you to download and save to your computer. So bear with me here a moment while I get it shared with all of you. Okay, you should see a pop-up window and then you can select that file and download it to your device. And if that doesn't work for you right now, you can download this PowerPoint from our website again. So if you go to the page where you registered, our webinars page, it is there for you at the bottom of the screen. You just have to expand under the Data Practices Potpourri option. Okay, so today's webinar is another installment of Data Practices Potpourri, and this is where we highlight some of the questions data requesters and government entities have raised in the past month or so. We will leave some time for a Q&A session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. And if you do that, make sure you choose all panelists when you send it in just so that we can all be sure to see them. You can start sending in those questions now, or you can wait until the end of the presentation. We'll make time for that Q&A then. Okay, so let's get started. So our first question for the day is regarding data inspection. So can a data requester bring a camera and take pictures of data they are inspecting at a government entity's office? So under Minnesota statutes 1303 subdivision 3A, data requesters may inspect and copy government data at reasonable times and places. So as long as the use of the camera is reasonable, requesters may make their own copies of data during inspection. And advisory opinion 04059 and 04051, as listed on this slide, discuss these rights of requesters to be able to bring in their cameras and make their own copies at inspection. We do often get questions regarding whether allowing a requester to bring a USB thumb drive to make their own copies of electronic data is also permitted. And here copying to a thumb drive would really fall more under the entity making a copy for the requester. So the entity is permitted to charge the actual costs for the electronic data copied, but also entities may have, security procedures in place that prohibit the use of thumb drives. There is a requirement that entities have security measures under 1305 subdivision 5. So some entities may prohibit outside devices from being plugged into their computers. And advisory opinion 02036, that's also mentioned on this slide, does discuss some of those security considerations when permitting devices at inspection. So while cameras are permitted for making copies of data inspection, but there's not an obligation here for the entity to allow thumb drives for electronic copies. And you'll see at the bottom of the slide, one important exception to everything quite often is body-worn camera data. So under Minnesota statutes 13825 subdivision 4, data subjects are able to inspect unredacted body-worn camera data. However, if they want a copy, other data subjects except on-duty police officers must be redacted. So this section is unique, right? Because the data available to inspect are different than what data are available in a copy. And so because of this difference between the inspection and the copy, individuals may not make copies of body-worn camera data during their inspection. Okay, so our next question is a bit more rare, but important to highlight, I think, um, so that entities understand their obligations here. So here, a member of the public asked for summary data about the race and disability status of an entity's employees. Does the entity have an obligation to provide this data? So generally speaking, entities are not required to create data in response to a data request. However, here, there is an exception for summary data. So summary data are statistical records and reports that are derived from private or confidential data on individuals in which the individuals cannot be identified. And this definition is from Minnesota Statute 1302, subdivision 19, and Minnesota Rules 1205.0200, subpart 16. So here in this question, a member of the public used the phrase summary data in their request, right? But note that some requests for summary data can look different. So if a requester comes to you and your entity asking for statistics that are derived from private or confidential data, and those data, those statistics do not exist, you're going to want to clarify with the requester if they are indeed asking for summary data. If those data do exist, it's not a summary data request. You can just, it's a regular data request that you can work on. But if they do not exist, then you need to see about creating summary data if they're going to make a formal request for summary data. So back to this example, a member of the public is asking for summary data, right? Under Minnesota statutes 1305, subdivision 7, the entity is required to prepare summary data if they receive a request in writing and the requester pays for the creation of the data. So under this provision as well, the entity may work with another party, including the requester, to prepare the summary data, provided that there is a non-disclosure agreement. So if you come across a request for summary data, please feel free to reach out to our office if you have additional questions. Okay, our next question is regarding closing data requests or abandoned requests. So how long must a government entity wait before closing a data request when the requester does not respond to follow-up questions for clarifications or to notification that the request is complete? So the Data Practices Act does not provide guidance on what to do in the case of an abandoned request, either at the clarification part of the process or after the responsive data have been compiled. The law does require access policies and procedures, right, to ensure that requests are responded to in an appropriate and prompt manner. So as part of your policies and procedures, you can consider having a process for these abandoned requests. So if the request requires more information before you can complete it and the requester does not respond to your questions, or if they never come in to inspect the data you've provided, you can then follow your data access policies regarding abandoned requests. And as part of those policies and procedures, we always recommend, of course, documenting your attempts to fill the request for the requester. So if you need more information from a requester before you can complete their data request, or if they did not come in for inspection, just make sure to send documentation that gives the date that the entity will consider the request abandoned and then closed. All right, our next question is regarding juvenile witness data. So we often receive questions about how to treat juvenile data under the Data Practices Act. Here we have an inactive criminal and we have inactive, criminal investigative data that includes information about a juvenile witness. How much information about the juvenile witness must we redact? So questions regarding juveniles and law enforcement data can get tricky. So I'm going to start with first, there is no general rule in the Data Practices Act that all juvenile data are automatically protected. So to redact identifying information on a juvenile, there needs to be a specific provision, right? Classifying that data as not public. So here, let's begin by presuming this is inactive criminal investigative data about an adult. So under Minnesota statutes 1382, subdivision 7, inactive criminal investigative data is presumptively public. Juvenile witness data in this investigative data are not automatically protected, so they are also presumptively public here. However, entities may determine that the subject matter of the investigation justifies protecting the identity of the juvenile, and this is under Minnesota statute section 1382 subdivision 17G. So in that instance, the entity should have procedures for documenting that determination so that they know that the identity of the juvenile will be private and need that redaction. All right, but this question gets more complicated if the criminal investigation is about another juvenile and not an adult. So in that instance, we look to Minnesota Statute 260B 171 subdivision 5, and that's in the delinquency chapter. And this provision will treat the data differently if the juvenile the investigation is about has a private hearing. If they have a public hearing, we treat the data like we normally would under 1382. But if they have a private hearing, all this data is private data and only available to the subject and those listed in 260B 171. Having said all that, this can get very complicated. You may have a lot of questions when you're working with juvenile data. Feel free to contact us, and our office is hosting a law enforcement data workshop in November. So if this is something you want to learn more about, you are welcome to register for our workshop. Another law enforcement question. So more and more law enforcement agencies are using drones in investigations or in response to emergencies or for requests for service. So one issue that pops up is how long does law enforcement need to retain any data from their drones? So drone data are relatively unique in that the classification statute for drone data also addresses how long entities need to retain the data. So usually government data that are official records are subject to the records management statute, which is Minnesota Statute 138.17, which creates obligations for data retention. So through that statute, standards for retention and disposition of official records are set via your retention schedule, and that's approved by the records disposition panel as listed in that statute. But here, it's different. Here, the retention for drone data is set out by statute and not by that records retention process in 138.17. So the retention period for drone data is very short. Law enforcement should delete this data as soon as possible and no later than 7 days after collection. And as you can see, this retention period, which is in 262.19 subdivision 6C, does not apply if the data are part of an active criminal investigation. So if the 7 days are up, but you have an active investigation, then of course you maintain that data as long as the investigation is active and the data are needed. So if you are a law enforcement agency and you have implemented drones or are considering implementing drones, I do suggest taking a look at 626, point 19, as this will lay out requirements for the use, policies, procedures, as well as classify the data your drones will create. So we sometimes hear from entities with concerns about how requesters may use data provided by the government entity. So for example, a company may request public data and the entity is concerned they will use this public data for commercial uses. Or, a data subject will take private data about themselves and share that data publicly once they receive it from an entity. So are there any limitations on what requesters can do with data once they receive it from a government entity? So generally, the Data Practices Act doesn't create any restrictions for the use or sharing of data after it has been provided to the requester as part of a data request. So once the requester has that data, Chapter 13 no longer applies. So if that company that requested public data from you wants to go and sell it, the Data Practices Act would not apply. If the data subject wants to post that private data about themselves they got from an entity online, they can use that data about themselves as they see fit. But having said all that, there may be certain circumstances where subsequent disclosure of government data without specific authorization is prohibited. So for example, other laws will apply regarding the disclosure of health records, right? It is possible also that some government data may also be copyrighted, and in those instances, the government entity must provide access but may be able to regulate subsequent use of the data. And an entity may also have a court order that limits subsequent sharing of certain data. So these are all, examples, and they're definitely exceptions. And many of them would be contained in statutes and sections outside of the Data Practices Act. So certainly, feel free to reach out to our office if you have questions about whether of any of these types of limitations may exist in a particular circumstance. All right. So here we have an open meeting law question regarding what materials should be provided at an open meeting. So a city clerk distributed electronic materials to all public body members before an open meeting. So do these electronic materials have to be included in the public meeting packet? This is an area where the language of the open meeting law has not kept up with business practices for public bodies. So Minnesota Statute 13D05, Subdivision 6, creates an obligation for public bodies to have materials available for inspection for members of the public at the meeting. And the language of that statute mentions copies of any printed materials related to the agenda items of the meeting that are distributed to the members. And that phrase printed materials doesn't really cover modern communication practices, right? Many of these public bodies are probably sharing the relevant materials electronically before the meeting. But given that courts have stated that they will interpret the open meeting law in favor of public access, and the fact that if we did treat materials that were printed and shared in print versus read only electronically, that could lead to very different levels of public access, right? So public bodies should provide access to materials related to the agenda items of the meeting that were prepared or distributed to the governing body, regardless of electronic or printed format. So this packet that the clerk is preparing should include all public data distributed to the body members. And if electronic data that is not public was distributed for the meeting, that's not included, but we're talking public data that was distributed electronically or in print. Advisory Opinion 08015 discusses the inspection of these electronic materials at an open meeting. All right. So those are our questions today, and we're going to get ready to take a look at some of yours. So if you do have questions for us, remember to use the Q&A panel. You would send them to all panelists so that we can be sure to see them. A few reminders on this slide. The slide deck again is available on our website, and you can access the recording. It will be uploaded to our YouTube page in the next day or two. I'm also in just a moment going to put an evaluation in the polling panel. So if you could please fill that out before you log off for today, that would be wonderful. You can let us know how we did, but you can also share what topics you'd like to see in the future so that we can make sure that these webinars are helpful for you. So I'm going to open up this polling right now. So hopefully you will see that poll. We do encourage you to fill it before you leave for today. And please continue to submit your questions in the Q&A panel. It may be a little quiet here for a moment while we're going through the Q&A, so bear with us here just a moment. Thank you.
All right, we have a lot of good questions so far. The first one that we received is how data on decedents relates to access to private data, including, for example, body camera footage that's classified as private under 13.825. So data on decedents is a provision that's addressed in Minnesota Statute 13.10. And what data on decedents says is that private data that would have been private prior to death of the data subject are classified as private data after the data subject has died. This same goes for confidential data on decedents. They're classified as confidential after death as well. And so the data on decedents provision indicates who has access to that private data after the data subject has died. And it says that generally a personal representative of the estate of the decedent during the period of administration, or if there's no personal representative that's been appointed, or after discharge of that personal representative, it's the surviving spouse, any child of the decedent, or if there's no surviving spouse or children, then the parents of the decedent. And so that provides you a structure of who will have access to that private data if a data subject has died. The question goes on to ask about verifying identity of those who access or request access to private data. The Data Practices Act itself doesn't outline how to verify identity. We have examples of processes or options for verifying identity on our model access policies on our website, but the Data Practices Act doesn't contain methods of doing so in the law itself. So for you, if you're a government entity and somebody requests access to private data, it is on you to follow your own procedures and policies to ensure that you're only providing access to that not public data to those who are authorized to see it. And so you would want to make sure that you're following your own identity verification procedures.
Okay, another question that we have here, it's more of a comment, but I think we can roll it in because it works with question number 6 from the webinar today. So, we have had people who want to view home plans that are copyrighted, and we have let the data requester review the plan but not take a picture. And I'm guessing the question is, whether that's appropriate. And I think that is. That's an appropriate way to handle data requests for copyrighted data. Again, when something's copyrighted, you can't just simply hand that over because there is the creator or the author of that work has a financial interest in maintaining that. And so in those situations, I think it's appropriate to allow inspection, but not allow individuals to make their own copies, and you're not obligated to provide copies in those situations. We do have some more information about copyright under the data practices area of our website, and it's advisory opinion 08-009, and that's advisory opinion 08-009, also talks a little bit about copyright and the Data Practices Act. But in those situations, again, allowing inspection of copyrighted data and then withholding copies is a permissible way to kind of work with those two different competing laws at times.
Just to add on to the copyright question, on that page mentioned on our website, we also provide a separate analysis for copyrights that are held by private entities versus copyrights that are held by government entities. And so if you're dealing with one or the other, that info page will be helpful in navigating how to provide access to that data. We have another question. What was the legislative intent when amending the Data Practices Act in 2005 by striking the words state agency, political subdivision, and statewide system and replacing the words with government entities? So I can't speak to what the legislative intent is on this off the top of my head, but I will say that government entity, the definition of government entity, which is in 13.02 subdivision 7A, says that a government entity means state agency, statewide system, or political subdivision. And so it looks like those 3 words were replaced by government entity, which is defined using those 3 phrases. If you'd like to discuss it further, you can always feel free to give us a call, and I'm happy to discuss.
Okay, another question here regarding investigations involving the maltreatment of children or vulnerable adults. And the question is, I believe it's a law enforcement agency that's asking this. They've been told that when a social worker requests data on individuals regarding the welfare of children or vulnerable adult investigations, they should always disclose the data. Is it fair to say this is always true, or are there exceptions? Because there are times that maybe an investigator says something might impair an ongoing investigation. And so when it comes to data practices, I wouldn't necessarily say anything is always true. There's always going to be exceptions, and you always need to look at the context of the situations. But when it comes to maltreatment investigations of children under Chapter 260E, or investigations of maltreatment of vulnerable adults under Section 626.557, both of those areas of law and those types of investigations do allow broad sharing of data among law enforcement agencies, social services agencies, maybe occasionally a school district or the commissioner of education, excuse me, when it comes to maybe maltreatment of children at a school. There is quite a bit of sharing authority under those various statutes when the various agencies, the social service agency and the law enforcement agency, are working together to investigate that complaint. There's language that they should work together to not duplicate efforts. And so in those situations, you really should have some sort of plan to coordinate with those other agencies. There may be times that you may not have to disclose everything, but there is that broad sharing authority there. And so generally you can share quite a bit of investigative data, including active criminal investigative data in those scenarios. And that's just a good conversation to maybe have with your legal counsel if you do get one of those requests, because there is that requirement that you not duplicate efforts, or you can coordinate to avoid duplicating efforts. So you have a lot of sharing authority there when it comes to investigating that specific incident. And so just a good conversation to have with your legal counsel to say, hey, we've got a request on this. and we don't want to maybe necessarily jeopardize an investigation. Should we be sharing this? Talking with your attorneys, but I'd say generally you are able to disclose that in many situations.
Okay, so we have a question. Are license plate numbers and driver's license numbers public in general? So what is the classification of license plate numbers? What are the classification driver's license numbers? It's going to depend on a number of factors, including why you're maintaining the data, how you obtain the driver's license numbers. We can start with license plates. In general, there's not a classification for license plate. We start out with that public presumption. However, if the reason the license plate is being maintained is because it's part of some sort of active criminal investigation, for example, the data might be confidential during that active investigation. Or maybe it's maintained as part of your automated license plate reader program. You might also have license plate data because it identifies stolen, lost, or confiscated or recovered property. Minnesota Statute 13.82 Subdivision 20 classifies that data as either private or non-public. So whether the license plate data is public will depend on why you as an entity are maintaining the data and whether there are any circumstances that would warrant classification, possibly under 1382 or another provision. So that would be the first question for you. As far as driver's license numbers, driver's license numbers, it depends on where the data came from. And there's also two different interpretations. So the Driver's Privacy Protection Act, which is federal law, protects certain data that come directly from the DVS database. Those are protected by both that federal law, the DPPA, as well as state law under Minnesota Statute 171.12 Subdivision 7. If you have questions about those two laws, you can always give us a call when you're trying to determine how to analyze the classification of this data. But generally, if your driver's license data auto-populates directly from the DVS database, or you pulled the driver's license data directly from that DVS database, it would be protected under both those laws. The DPPA has an exception for use by government entity in carrying out its functions. This is where there's a decision point for entities that comes into play on whether this exception includes complying with the Data Practices Act as one of its government functions. I believe that this exception has been discussed in Wisconsin case law, but not yet in Minnesota case law. And so I think that there's a risk assessment involved for Minnesota government entities on whether one of those exceptions applies. Again, please feel free to give us a call if you want to discuss that decision point in more detail. And it will just depend on how you've collected that data.
Okay, I think I'll answer this last question here and then maybe we'll wrap it up. When a requester says that they want to inspect or have data delivered electronically and the entity responds asking which one he wants, does the entity remain obligated to respond if the requester does not specify? So in general, I would say yes, you still are obligated to respond in those situations because if you don't have any other questions about the nature of the request or any clarifying information in order to fulfill the request, I think you're still obligated to respond and maybe perhaps in that situation, prepare the data, have it ready for inspection, and then be ready to deliver it electronically, or maybe at that point you could just deliver it electronically if you're not planning on charging any copy costs in those situations. But just generally, I would say if there's not a question about the substance of the request or any information about the request, it's more about how they want it delivered, then I think you're still obligated to respond in those scenarios. And so again, it's a little challenging if the requester isn't responding by any means, but maybe a suggestion here is to take a look at your forms and to say, you know, if you check both, then we'll expect that you're going to inspect the data. Or if you check both, then we're just going to electronically deliver it to you. But the Data Practices Act does allow individuals to inspect data and then obtain copies. And so I think simply not clarifying which way they want the data delivered, I don't think that's enough to say, hey, we're going to close your request. One side question here that's also a little bit direct comment here, you know, someone said that they didn't see any guidance on abandoned requests in our model policies and whether that's something we would consider adding in a future revision. I've taken a note here that we will take a look and see if there's any information that we might add when it comes to abandoned requests. One example policy that you might want to take a look at is, I believe, the Department of Administration's policy. We're part of the Department of Administration. I do believe we have some language in our policies about abandoned requests. So for the time being, if you take a look at the Department of Administration's policy, you would be able to find some additional information there or guidance about abandoned requests.
Thank you so much, Casey and Katie. And thank you everyone today. If you have not already filled out the poll, I do encourage you to do so. And we did not get to all the questions today. I apologize, but we will follow up with those individuals to provide answers to those questions just to make sure they get the information they need. Of course, you are welcome to reach out to us directly if you have any additional questions. Our contact information is here. Feel free to shoot us an email, give us a call. We are happy to chat about these issues with you anytime. We're around to answer your questions. So thanks again, everyone, for coming to our webinar today, and we hope you have a good rest of the day. Take care.